Court does call the case of the People versus Eric Buckner.
On behalf of the people. And Assistant Public Defender Natalie Pate with on behalf of Buckner, who is present on Zoom. Sir, can you please state your name for the court?
Eric Buckner.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review with my client both the PSIR and recommendation as well as the written victim impact statement. As to the PSI, we have no material changes or corrections. And as to the recommendation, we would respectfully ask that the court adopt it.
Probation, Your Honor, it was my understanding that the victim, Tamika King, was going to be present via Zoom,
We do have her.
and she would like to address the court.
She wants to address the court. Okay, very good. All right, Ms. King.
Hi, Your Honor.
Hello. Just one moment. I'm going to try to move this and replace it. Got it. Okay. What's your name?
My name is Tamika King.
All right. And what did you wish to tell the court, ma'am?
I just wrote a statement for the court, and I would like to thank you for letting me address the court today, Judge Simpson.
Not a problem.
Okay. This year has been one of the most painful and frightening times of my life. I stand here today not because I want revenge, but because I need safety, accountability, and healing for myself, my children, and even for the man who hurt me. The abuse I experienced changed me. It broke pieces in me I am still trying to rebuild. I have lived in fear, confusion, and emotional pain that no one should ever have to endure. I'm learning to breathe again, to trust again, and to feel safe again. The impact of what he did is something I carry every single day. I want the courts to understand that I did not ask to be in this position. I love someone who ended up harming me. And even though he hurt me deeply, I do not believe he is beyond help. I do not wish for him to be destroyed. I want him to be reformed. I want him to receive counseling, anger management, mental health support, and whatever intervention is necessary to prevent this from happening again to me or anyone else. But while I want him to get the help he needs, I also need the court to understand this. My safety must come first. My peace must come first. My healing must come first. I cannot move around if I am living in fear that the person who abused me can repeat the same behavior without consequences. I cannot heal if I'm constantly looking over my shoulder, and my children cannot thrive if they see their mother frightened or harmed. So I'm asking the court for protection, real protection. I am asking the court to take this seriously because the abuse was serious to me. I am asking the court to hold him accountable, not out of spite, but because accountability is the only path to change. If he truly wants to be a better man, a better father, a better human being, then he must do the work. And that requires structure, consequences, and treatment. He does not need freedom from responsibility. He needs guidance, boundaries, and help. Your Honor, I am choosing myself today. I am choosing safety. I am choosing healing. And I am choosing a future where I do not have to fear the man who once promised to love me. Thank you for hearing me, and thank you for protecting me.
Ma'am?
Yes, sir.
I want to just say this to you. The last time I think you had fallen ill,
Yes.
right?
Mhm.
And you were going to try to send in a message to us.
Yes.
And then at some point you were going to try to appear or vice versa. Anyway, you couldn't make it. And I adjourned this out, making sure that we heard from you. I just want to tell you that after listening to you, I'm so glad we did.
Thank you.
I just hearing your words and an understanding of what you want. And I think for a lot of victims and survivors of domestic violence, they really need to hear those words about, particularly, and the most poignant words are that you're choosing to put yourself first,
Yes.
right?
Mhm.
And so a lot of times that's not said, but I think you said it twice at least during your statement, and I can appreciate that. And no apology needed for that because that's what really should have happened always anyway, right?
Yes.
All right. And from my standpoint, so that you also understand there's, while I certainly am constrained by certain portions of what the law will allow me to do, one thing you can bet for me, and that is that I'm going to do everything, and my staff here in probation, we're going to do everything in our power to try to give you what we can in terms of that safety and security back, Chief.
Thank you.
Okay. You're welcome. Thank you. All right. Yes, yes, you may.
We're good.
We're good. Okay. All right. Court recalls case, people versus Eric Buckner.
And on behalf of the people.
And Assistant Public Defender Natalie Tate with and on behalf of Mr. Buckner. Sir, can you please state your name, please?
Eric Buckner.
Go ahead, Mr. Payne.
Thank you, Your Honor. I don't have anything further to add. We do not have any material corrections as far as their pre-sentence investigation report goes. And as to the recommendation, we would ask that the court adopt it. I did discuss with Mr. Buckner, since the court passed the matter, the conversation we had at the bench conference, and he does understand that.
Mr. Buckner, anything you want to say?
I just basically want to apologize to the courts for everything and take care of this once and for all. That's all, Your Honor.
Sentence of the court, place you on probation for a period of 24 months. You're to pay $655 fines and costs, $720 probation oversight fees. When can you get that paid, sir?
Well, next couple months, that's why next couple months I could get on some type of payment plan or something like that.
What I'll do is a payment plan as arranged by probation for that.
Okay.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a domestic violence program as directed by probation. You are to have no contact whatsoever with Tamika King. You are not to go to the home or employment of Tamika King. You understand that, sir?
Of course, Your Honor.
You are not to assault, terrorize. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to report to probation as requested by probation. That would include any home visits. You are to comply with all circuit court orders if there are any. I am going to order that defendant needs to be placed on a GPS home confinement tether. He will be allowed out on that tether from 8 a.m. to 6 p.m. for employment purposes only. All right. I will then set a review hearing on this case to be held on February 2nd, 2026 at 1 p.m. I will order 365 days in jail. Credit 4 days, sir. The balance is suspended.
I have one question, Your Honor.
Yes, sir.
Now you said only work. I have medical too. You know, I was bit by the police dog over 25 times, so I got a lot of medical issues also. So could I be out for medical and work use only?
Well, that's why those dogs shouldn't be antagonized. But as I had indicated to counsel when we were at the bench, yes, we will work around any scheduled medical appointments that you have that
Yes,
don't
I have
fit
surgery.
in that window.
I have surgery. Okay, go ahead. I'm sorry, Your Honor. Go ahead.
No, Go ahead. I understand that there may be surgery scheduled. Talk to your attorney about that. We
Okay.
will be we're willing to work around all of that. We would just need to know when it's going to occur and the like.
Okay.
All right? Thank you. The
Yes.
court does call the case of the people versus Timothy Reed.
And then on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Reed. Mr. Reed, state your name for the record, please.
Timothy Reed III.
All right, where are we on?
So, Your Honor, this was adjourned out due to a bond violation for a Tether tamper. I am asking the court if Mr. Reed can plead no contest to that for potential criminal and civil liability.
I'm not going to have a no problem. I'm not going to have no problem. I will not have a problem with a no contest plea to the violation. Although, I have some concerns that there is not an admission as to what he may have done in this particular case, because initially I was receiving information that he had not cut the strap, but
My concern, Your Honor, is I'll tell you, Mr. Reed, I think is ready for that. My advice to him is a no contest plea because of the liability. He was informed at when the tether was placed that if he tampers with it, he can be charged. I know Your Honor have seen people be charged. So that's my concern right now, is with the potential of that.
okay, that I understand what your concern may be. I'm just telling you how I'm going to be viewing that. Because as I look at the pictures, it's clear to me it's cut. It's also clear to me that the explanation of it being, I think it was a Milwaukee knife, it doesn't fit. Because the pants would have had to have then been ripped, and his excuse that there were then two pair of socks is just not. So
Well, given that, I mean,
I'll accept there's no contest plea to the violation. I'm not saying that I won't.
yeah. Would Your Honor give me a chance to speak with him in holding, and he can decide what he wants to do given what the court has said?
I think because we have to wait because we got one Spanish at the end anyway. Back. Okay, yeah, I'll take it back.
Okay.
So I got a whole 5 days off. I come back. First case I call, I can't do anything. Thanks, Barry. Counsel approach on that last matter, please. Or recalls the case, People versus Timothy Reed.
And then on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Reed, who is approaching. State your name for the record, please, Mr. Reed.
Timothy Reed III.
Your Honor,
Yes.
excuse me. Thank you for the opportunity to speak with Mr. Reed in holding. I have explained all of his options, and I think he wants to move forward and admit to the violation today.
Is that correct, sir?
Yes, sir.
You did not, and the violation would be that the tether was cut.
Yes, sir.
All right, and you admit to that.
Yes, sir.
Anything you want to say before I sentence him on this?
I think Mr. read, I'm going to let him speak on his own behalf. He's mentioned to me that he wants to speak to Your Honor. I will say after our hearings, prior to the holiday, he did call me and kind of give me the lowdown on everything. I think he's incredibly remorseful for not being completely frank with myself and Your Honor at his last hearings. I think he's been in custody for 2 weeks now, and says he knows he needs to be better, and is dedicating himself to doing that moving forward. He really does want to get out of custody and get back to work, to support his children. He said this is the longest amount of time he's been away from his children, and that's been one of the hardest things that he's had to experience during this whole ordeal. But I think the time that he's had to think has really put things into perspective. So I'm going to turn it over to Mr. Reed, because I think hearing from him directly will emphasize that.
Go ahead.
So yes, I did intentionally cut the tether, but once I did it, something snapped in my head and I realized I was like, what am I doing? Like I know this is wrong. And I immediately got a hold of the emergency tether line. I called them, told them what happened, and they had me send.
Well, you gave a version of what happened.
Yeah, the version instead of telling the truth, which I definitely need to do point blank. Because when you don't tell the truth, it just makes things worse. I did send pictures in. I still went to community corrections the next morning to get a new tether, and still showed up to court. And I've definitely had a lot of time to reflect on what I've done these last 2 weeks. It really hit me hard Thanksgiving morning when I woke up and realized that I wasn't gonna be able to see my kids for the holiday. And then I called my sister to ask if the kids were going to be at my family's Thanksgiving. And then when I found out that they weren't and I wasn't going to be able to talk to them that day, that also hit me really hard. And realizing that if I don't take accountability for my own actions and actually do what I'm supposed to, it's never going to get any better.
Did you really think I was going to buy your story?
I'm gonna be honest with you, no.
Then why'd you keep doubling down?
I have no idea, sir.
I mean, I'm looking at the cut on it, and I had it pretty much figured out.
Yeah, I even went and got super glue to try to super glue it back together.
Pardon?
I even got super glue from the store to try to super glue it back together. And then I realized that wasn't working. So
I mean, what were you thinking when you just decided you were going to cut it?
I'm be honest, I don't know. I don't plan on running or anything. I've got kids that I want to be able to see, and I want to get out of this whole process and be able to continue on with life and not get in trouble again. I know what I did was completely wrong, and it should have never happened in the first place.
And you know, had you just told the truth over here on November 17th,
Yes, sir.
probably would have been out for Thanksgiving.
Yeah, I realized that.
All around this is just stupid.
Yes, sir.
Anything else you want to say before I sentence him?
Nothing, Your Honor. I'd ask that the court sends him to credit for time served and reinstate his personal bond. As we say at the bench, he's being seen by Judge Perry on Wednesday. His bond there is denied, but she's kind of indicated she's waiting to see what Your Honor does.
Sentence you to 14 days, Washington County Jail, credit 14 days served. Your previous bond with its conditions is reinstated. Ma'am, you are trying to address the court. What is she?
And that's correct, Your Honor. The victim is present to address the court if the court wanted to reverse.
Yeah, what are we gonna do on this?
I'm asking to set for final settlement.
Are you gonna be ready Friday?
We asked for that date if the people will be ready, but I know it's.
All right. Then I'll set jury final settlement conference.
What do you say?
What is that?
It's the same.
December 5th. Today's the 1st. December 5th. Today's the 1st. That keeps going on in my head.
It's already December. Can you believe it?
Yeah, that wasn't my point, but okay, disparity. December 5th, 2025 at 9 a.m. Jury selection, if necessary, in this case, will take place December 8th, 2025 at 8:30. Did you want to address me, Esteban?
You'll sit where Natalie's.
Yeah, you need to have a sponsor. Hello.
Just wanted to let you know because he's been in
Can
jail.
you state your name?
Oh, sorry, Rosa Bannock.
Yes.
I'm gonna try not to cry because I am in that state right now. But because he's been in jail, I have lost my job. I really just hope that you can release him. I don't. And I've also been sick for like the last 2 weeks. My kids have been obscenely misbehaving because they miss him. And my daughter has a neurodegenerative disease, doesn't understand what's going on. Her speech has gotten worse. It was getting better. And I just need him released so I can work and pay rent.
I understand that, but you also understand how it turned out that he ended up in custody.
Yeah, that's his decision. I mean, that was his.
No,
Oh, that. Well, anyways, but seriously, like, if I become homeless again, dude, because I can't pay rent, the only way my kids can be safe and still be able to go to school, because shelters are probably full right now, is that he goes back to his sisters, because we have a great co-parenting thing where he takes them on the weekends. His sister already agreed because she knows the situation to take the kids. But he has to be there. I have no help. My dad's in Serbia. My mom's unreliable. My car has been broken down for months now. I don't have anywhere to go with my kids. I can manage myself, but I can't manage myself with my kids because I don't have any support.
I understand, and quite frankly, back on the 17th, I wish I hadn't had to do what I did.
And I think he, at this point, has learned. He is pretty, I think he's just manic, and that's probably why he did that, to be honest.
What?
Manic. He has bipolar.
All right. Okay.
I'm being
Thank you.
serious.
Well, he's gonna get out.
Okay.
Okay.
Can it be before Friday?
He's getting out of jail?
Yeah.
Well, I was gonna let him go today.
Oh,
You want me to keep him till Friday?
no.
You got something to do?
No. I ended up getting a new job. It's only part-time, but I work Friday and they don't go to school on Fridays.
I sentenced him to 14 days, credit 14 served,
Okay.
stated his previous bond conditions.
Thank you.
All right.
I really
And he will
appreciate
be
it.
out as of today at whatever point the jail releases him.
Okay.
Okay?
I really appreciate it. I'm serious.
Not a problem. All right.
I'm just stressed.
Yes. All right. Take care. All right. Anything else we need to do in this? I don't think so.
Something else, sir.
All right. Thank you.
On the record, in the matter of the State of Michigan versus Shameen Johnson, 25974.
Good morning, Judge. Attorney Corey Westmoreland appearing on behalf of Ms. Johnson. Ms. Johnson, would you please state your full name for the record?
Jermaine Johnson.
All right, good morning. And
morning.
so, counsel, I know that there is some, before your client was in custody, your client indicated she was interested in the treatment court. And so we rescheduled sentencing because she did not pay attention to her dates. In the interim, so that was November 13th. In the interim, it appears as though your client violated the terms of her GPS tether because she was not at the location she's supposed to. She was not at the housing she was supposed to be at. And claims that she doesn't have housing, therefore she can't technically be tethered, GPS tethered. That's what it appears to be.
I thought it was because her GPS tether ran out of battery. I don't know what report you have. I was just getting this one.
Does it look like this?
Yes.
Yes, that's the same one I have. Yeah, so she had alerts for low battery, given a verbal warning so that she could charge it. And she did not. And then she stated she was homeless. Or she's having a hard time finding housing.
Correct.
And so we have to have stable housing to be tethered. Okay, and so counsel, let's hold the bond violation for a moment. Is your client still wanting to be screened for the treatment court?
Your Honor, I didn't know anything about that. I was just given her as a client 7 minutes ago.
Oh,
So I know nothing about this
so then
matter.
you need to speak to her.
I didn't know she was here for sentencing. I just knew she was here for a bond violation. That was it. That's all I was handed.
So did you speak to her about the bond violation?
I did.
Did you speak to her whether or not she's been communicated with regarding the treatment court?
I knew nothing about that.
Okay.
All I knew is she was here for a bond violation because her tether ran out of battery.
Okay, Miss Johnson?
Yes, Your Honor.
Okay, hold on, let's go off the record for just one moment.
Okay.
We'll adjourn the bond hearing too. Okay, all right. So we're back on the record in the matter of Shameen Johnson. And so, all right, so ma'am, this is the only matter that you have pending, correct?
Yes.
Okay, so what we're going to do is I'm going to indicate that we're going to adjourn the bond violation hearing because you're going to be reporting this afternoon here to the treatment court, correct?
Yes.
Okay. So we'll set this for January 5th. With your sentencing. And then what I'll do then is I'll indicate a $5,000 personal bond. And I will remove the tether provision for right now.
Thank you, Your Honor.
All right, I expect to see you here at 1:30. You're scheduled for 1:30 today. Is that correct?
Correct. I'm scheduled for 1:30 today. I'm in
Okay.
Wayne County.
Okay, so we'll see you at 1:30. You should be released by then. So we'll see you here at the 27th District Court by 1:30.
Thank you, Your Honor. I'll
Thank
see you
you.
there.
Have a good day.
You
You're
too.
welcome.
Bye.
Thank you. Okay. City of Riverview versus Margie Cara, 17988.
Right, Your Honor. Good morning, Your Honor. Attorney Michael Kelly, P77187. On behalf of Ms. Carroll, who's present standing to my right.
Good morning. All right, and your name, please.
Margie Carroll.
Okay, are you picking her up? Okay, can I have the two of you switch spots, please?
Yes, my name is Margie Carroll.
Perfect, thank you. Okay, and if you can just please keep your hands out of your pockets. And I really did hate to tell you to take off your hat because the whole outfit looked very cute. But can't have hats on in court. So, all right, counsel, today's the date scheduled for your motion application to set aside conviction. And what would you like the court to know?
Well, I have filed a brief in this matter. I think outlines pretty well the circumstances before the court. Not only has the Attorney General's office rendered opinion that Ms. Carroll is eligible, but also for the reasons contained in my brief. I do believe that she's an exceptional candidate for the consideration being requested. She has come a long way since her contacts with this court back in 2016. She is working full-time. Your Honor, she has completed nursing school. She's on her path to enter her profession. This is, however, a hang-up in her moving forward. She has had to miss opportunities and precluded from opportunities in the past because of her criminal record. She did get a prior marijuana charge cleaned up back in 2022. The next step was now moving forward with this OWVI charge. So I believe that the post-conviction circumstances and behavior here are reflected in the Register of Actions, which show that she did complete all orders of the court, all rehabilitative programs, fully reevaluated her relationship with alcohol. Now she's in this incredible position to enter into a field that's in much demand, in need of her services. And I think she takes this as an opportunity to really be validated for the efforts that she's accomplished over the many years since her last contact with this court. So for the reasons contained more fully in the attached brief, I'd ask you to grant the application to set aside this conviction.
Okay, so a couple of questions. One, you indicated that 2022, that's when the marijuana possession was set aside, or that's when the conviction was?
Set aside.
Okay, and when was that conviction?
2002 or 2003.
Okay. And
before this,
what's that?
it was well before this incident.
Okay, and the court will note as well that many of those possession charges were automatically set aside as now that's the status of that.
I had to pay for it to get it. I had to pay for that, which I didn't, but
Well,
I could
so,
to the nursing program. I'm sorry, Judge.
no,
Yeah.
you're okay. No, and there are some that were automatically set aside, some that were not. So I don't know what was the qualification for it to be automatically set aside. So you're in the nursing field?
Yes.
Okay, and so what opportunities have you had to pass up as a result of this conviction?
Well, as of right now, what I'm doing is I'm battling right now my life, my future. So I'm having issues with testing for the NCLEX PN from Laura from the Board of Nursing because this explanatory OWI, which I'm not proud of at all, I take full responsibility, but that is what's prompted me to move forward with trying to get this just off my record so that I wouldn't be looked upon as some type of animal.
No, you're not an animal. And, it appears though it was, just a poor decision that day. It doesn't mean that you're a bad person or anything else. So, the court will note after hearing from counsel, hearing from Ms. Carroll, reviewing the report, from the Attorney General's office, the lack of continued criminal history, and the brief that was submitted by counsel as well. The court, in noting that this is Ms. Carroll's first violation of operating while intoxicated, the court will note that it does appear as though Ms. Carroll has benefited from the rehabilitative programs that she was ordered to complete as a condition of probation at this court, as well as Ms. Carroll's post-conviction circumstances and behavior. And the court does find that it is consistent with public welfare to grant Miss Carroll's request and set this matter, this conviction aside. So the court will grant the motion. And did you already submit an order, counsel?
I did.
You're welcome. Good luck to you, ma'am. Let me just,
Make sure you have it. I have a copy for me.
I do have a copy. Okay, good luck to you, ma'am, on your NCLEX.
And can she get a, if she waits, can she get a copy of that today or?
I believe that she can.
I know it still needs to be entered by the court, but for her own records, it would be helpful that she has a copy as soon as possible.
Submit it to the law.
Yeah.
Okay, so just have a seat in the lobby and we'll get that to you as soon as we can, okay?
Thank you.
Have a good day. Okay. Okay, so we are on the record in the matter of Caleb Berry, 25871.
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Berry. Mr. Berry, please state your full name. Caleb Berry.
Okay, and 25870. There's two of them. Okay, today's the date scheduled for a probation violation. Your client was sentenced to probation on October 6th of this year. And on both larceny counts. And it's alleged that your client failed to appear for drug testing November 10th, tested positive for marijuana October 22nd, failed to appear for probation November 20th, and failed to make any payments as ordered and agreed upon. And counsel?
Yeah, I did have an opportunity to speak with Mr. Berry with violations. At this time, we are prepared to waive any sort of contested hearing and enter a guilty plea on his behalf.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and you heard the plea that was placed on the record, correct?
Yes.
As to those allegations, sir, how do you plead?
Guilty.
Also, let me clarify as well on 25870. All the other allegations that you failed to complete workforce is scheduled. And so as to, and I'm not sure why it's on one and not the other, unless I didn't order workforce on this one. Let me just see here. Nope, I ordered workforce on both, so I'm not sure why it's on one and not the other. But in any event, as those allegations, how do you plead?
Guilty.
And you've gone over your advice of rights for probation violation purposes with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand that by entering into this plea, you'll be waiving some of those rights. You also understand, sir, the possible penalty as a result of your plea.
Yes.
The recommendation here is for your under advisement status to be revoked and 3 days additional workforce, $50 probation violation fee, revoked probation, and mandatory jail for any future violation, as well as 30 days suspended jail. Do you understand that's the recommendation?
Yeah.
Knowing all of that, do you want to continue with your plea?
Want to continue with your guilty plea? Yeah. Now we discuss that small suspect. Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Aye.
All right, and counsel, if you can please pardon your client.
Mr. Berry, are you currently on probation through the Wyandotte District Court? Yes, sir. As a term and condition of your probation, are you to attend your scheduled probation visits? Yes. Did you fail to appear for a visit on November 20th of this year? Yes. Did you fail to pay costs and fines as ordered? Yes. Did you test positive for marijuana on October 22nd of this year? Yes. Did you fail to submit to a drug test as ordered by probation on November 10th of this year? Yes. And did you fail to complete your workforce as ordered by probation? Yes. Okay. And you understand those are all violations of your probation? Yes. Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations. Indicate technical violations 1 through 5 will enter on 25870 and 1 through 4 on 25871. Counsel as to the recommendation.
Yes, Your Honor, I would just ask that Mr. Berry be given an opportunity to complete probation. He's been having a tough time finding work at this time. I explained to him just about every place is looking at least for some seasonal holiday help at this time. So, you know, it may not be his dream job, but at least it's a job and it will keep him out of jail. So he's hopeful that he will find gainful employment here shortly. But ultimately, that's what's holding him back as far as being the workforce, because it all costs money and drug testing and everything else.
Well, probation doesn't cost money to come to his probation appointment.
He did receive a notice that he did have an appointment, but I did let him know that he needs to stay in better contact with the probation officer to ensure that he doesn't miss his appointments.
Sir, are you still residing at the home on Vanessa?
Yes.
Okay, well, it was mailed out to you October 16th for November 20th at 9:30.
I don't check the mail.
Well, sir, first of all, okay, sir, how old are you?
19.
Okay. You don't check the mail. Do you check your phone for text messages?
Yeah.
Do you check your phone for email?
No.
No. Okay. How do you expect that you're going to be notified of anything, sir, if you're not taking responsibility for checking email and checking the mail? I mean, how do you think you're going to get that information? You're not. So I'll tell you this, sir, you claiming that you didn't know because you don't check the mail, that's on you. The court sends notice as it's required to do. We can't make you check your mail, but when you don't check your mail, sir, then this is what happens. You have consequences for not being responsible. Okay, how does not having a job, how are you testing positive for marijuana October 22nd?
What's that? Oh, that was my first drug test that I had. So, like, well, I thought you could I don't know, I tried my hardest to not have marijuana. Previously, when he was in court, he did indicate that he was going to test positive, and that would be a hope that that'd be used as a baseline.
Well, sir, the court ordered you on August 25th to not use any alcohol or drugs unless prescribed.
And I didn't, Your Honor.
So then 2 months later, you're still testing positive for marijuana?
2 months later.
Yes, it was. And when you were last in court on October 6th, when this court sentenced you, sir, that was 2 weeks later. Yes, the 22nd of October. It was 2 weeks later from that. And so, when's the last time you were working, sir?
About a week, or like October 10th.
Okay, and so why are you no longer working?
Because the government shut down, and then now it's back open.
I'm unclear, sir. You worked for a private employer, correct?
No.
You worked for the government?
No,
So then
I got laid off.
so you worked for a private employer.
Oh, yes.
So when did you get laid off?
Till the 10th.
Okay, and so are you receiving unemployment benefits?
No,
And is that because the government was shut down, or did you not apply for those?
I even looked at this.
Sir, how long were you working?
About a year.
Okay. And so you were laid off?
Yes, Your Honor.
Okay. So how do you suppose you're going to support yourself You weren't given any information about unemployment benefits. You really should look into that, sir. Perhaps it's in your mail that you haven't checked.
Yes, sir.
Okay, and so your employer isn't calling people back to work?
I don't know.
Have you been contacted with your employer?
No.
Okay, so where have you applied for work in the meantime?
Ford and Dearborn and Yapco and Romulus. And like Amazon.
Okay, anywhere else? Just the three places?
Just those three places for now. Start looking right away.
Okay, sir. How do you support yourself? Do you live at home?
Yeah.
Okay. So, all right, if you were to test right now, sir, what's in your system?
Awesome.
And I believe workforce is previously scheduled. Why didn't you show up for workforce, sir?
For today,
No, sir, when you were previously scheduled for workforce.
I didn't have the money.
Well, that was assessing your fines and costs. You don't have to pay it the day that you show up.
Yeah, I didn't have any gas for my car.
You can ask somebody to drop you off. Well, who do you live with at home, sir? Okay, you couldn't ask her to drop you off?
Jeez.
What? What do you mean you don't know?
I don't know. I can't remember like if she was there that day or what, you know?
Well, sir, if you have something that's scheduled, did you not plan to have somebody give you a ride?
Or sometimes my arm doesn't even go off. So
Sir, you need to take a bit more responsibility and accountability. For your daily responsibilities, I guess is the word for it. Well, here's what the court's going to do. You've only been on probation for 2 months, not even 2 months. And now here you are with 5 technical violations. So, did you communicate, sir, with your probation officer that you were no longer employed?
yes.
Okay, and that you're having difficulty with finances?
Yes.
Okay, and so what's the cost for the drug test?
$26.
Okay, and so are you able to borrow that money from anybody, sir?
I might be able to.
Okay. Well, I can tell you one thing that you're going to be able to, that you're going to do is submit more applications, sir. Even if it's not necessarily for the job that you're looking for, you need a job. Whatever it is. Okay, so here's what the court's going to do. The court's going to revoke your under advisement status. The court's going to order $50 probation violation fee, 3 days additional workforce, 30 days jail, suspended, submit 30 job applications per week, and submit proof to your probation officer. And then revocation of probation, mandatory jail for any further violations. Any questions regarding any of that, sir?
Yeah. Okay.
All right, I'm going to have you go over to probation. And then they will get you an amended probation order. As well. Okay,
Thank you, Judge.
thank you. Have a good day.
You too, Your Honor.
This is Dawn McDaniel versus Ashley Souter. This is a termination of tenancy case. Ms. McDaniel wants Ms. Souter to move. Ms. Souter, what's your position?
Okay, so Dawn has issues with me as of August because Ryan McDaniel is the landlord of the house and owns the home. I went in and I spoke to him on the last payment I was able to give him, and I talked to him about paying the $200 a week, so $800 a month. Because the house needed work, we agreed on it. Dawn was nowhere around. Well, Dawn got a whiff of it, and Dawn started to harass me. I got like different evictions that she had Daniel Carter bring to me at one point. Then she brought me one back in August, saying I owe $21.50. I don't owe any rent. And then I noticed on the new eviction, she says I owe $78.50. And I'm like, how do you go from $78.50 from August to the time you filed? This has nothing to do with Dawn at all. This wasn't.
Well, at this point, she's not asking you to pay rent. She's asking you to move. So, Miss McDaniel, do you own this house? Your microphone is on mute. Your microphone is on mute.
And I have the proof too. And I've even dropped off money orders to her mailbox. And she had told people she's okay.
Miss Souter, you stop. Miss McDaniel, will you unmute your microphone and join us here?
Judge Middleton?
Yes. She
Judge
claims
Middleton?
that you don't even own the house. What's your response to that?
I can't hear him. Hello? Can you
Yes.
hear me now?
Yes.
Can you hear
You're
me?
moving to evict
Okay.
Ms. Souter. There's no lease.
My response
She
is,
says you don't own the house. Who owns the house?
I'm the manager for the house because my son owns the house. It's a property that I used to own that I gave my grandma for $1 next door to my house.
All right, so your
my old
son
house.
owns the house?
Yeah, he got it for an inheritance. And I'm
Say that
managing
again?
it. He got an inheritance after grandma died.
Okay.
So I'm managing it for her. I actually moved Ashley for 3 days to help her move from her abusive husband, who now lives with her. That was what I was told. And
All right, well, you can't bring this case. You don't own the house. You're not, if you're managing, unquote, managing it, you're acting as a lawyer for somebody else.
Well,
you don't
we
own
tried
the
to do-
house. You don't have the authority to evict her. So if somebody else wants to evict her, whoever owns the house, they can pursue it.
And can I
But
say
this-
something?
No, I don't need to hear any more. Case is dismissed. Plaintiff does not own the house.
Your Honor, she hasn't paid rent since
No,
June.
I have done, and I turned in money orders, and you denied Ryan to cash them, and I
Asked them to
Once
move.
you file a termination of tenancy action, you can't accept rent. But you didn't do this right. If he wants to evict her, he can. You don't have standing to do anything.
Okay.
I don't know if she's paid rent or not, but you don't have the authority to kick her out. So the case is dismissed. If he wants to file an eviction, he can. All right, you're both free to go. And Ms. Souter, once they file a motion to terminate tenancy, they can't accept your rent. So this case is dismissed.
Right.
All right, Ms. McDaniel, maybe you can start over again, but this isn't gonna get it. Well, that's kind of afternoon we've been having here today. Next, we have Hometown Welcome Program versus the Waxahatchee Son. Mr. Andrew Rognus is here on behalf of Hometown Welcome and Dan Tollefson. I assume Scott is here on behalf of the Waxahatchee Son. This was a substantial judgment, $10,057.38. Hometown Welcome was represented by Mr. Rognus. Waxahatchee Son was not represented. They are located in Waxahatchee, Texas. This is not a small claims case. It's a general civil case. And Mr. Scott Brooks is representing the Waxahatchee Son. And I don't believe he's an attorney.
No, I'm not.
But anyway, they filed this action. You filed an answer. They filed a motion for summary disposition and a hearing, and you didn't show up. So on October 13th, I issued a judgment in behalf of the plaintiff for $10,367.38. Mr. Rognus has done a pretty good brief in this matter, setting forth what the standard is to move to set aside a default. One, you have to have a good reason for not appearing, and then you have to have an affidavit of meritorious defense. Mr. Rognus, what's your position here?
Well, Your Honor, I think as we indicated in our brief, you cannot appear without counsel unless you're an individual representing yourself. And in this particular circumstance, no brief, no affidavit, no cause, and no basis for the motion to set aside the default. I mean, pick any one of those reasons.
Mr. Brooks, what's your position at the Waxahatchee Son?
Well, we responded to what we have received. I'm not an attorney, and I own my company, and so I'm representing myself and the company.
Well, you can do that. Is it
Okay.
a corporation?
Excuse me?
Is it a corporation?
Yeah, it's an LLC.
Well, then you can't represent it. You can't treat it as an independent business for one purpose. Someone sues you and they say, wait a minute, it's a limited liability corporation. I'm only limited to the assets of the corporation, not my personal assets. And then show up to represent an LLC. I'm not sure exactly what the law is in Texas, but in Michigan, an individual can't represent an LLC or a corporation. So that's one problem. You're not an attorney. Secondly, you have I don't know whether there's a meritorious defense, but you didn't show up for the hearing. And in your letter, you say, it's my fault. Accept my apologies. The reason is entirely my fault. That's not a good reason for setting aside the default that you forgot to come that day. So there, as Mr. Rognus said, there's multiple problems. One, you can't represent the Waxahatchee Son. Two, you haven't stated a good reason for failure to appear. Three, there's no affidavit of meritorious defense. You sent a letter which explains some things, but it's not the same as an affidavit, which is a sworn document. So probably in hindsight, you should have taken this to an attorney as soon as you got it. But I'm declining to set aside the default.
What is the letter that I received saying the court has accepted your motion to set aside default judgment?
I set aside the motion to set it for a hearing, which I just did. That doesn't mean you win.
Well, I'm not necessarily looking to win. I'm looking for a judge to hear what's fair. I don't know what the laws are in Texas as it relates to an attorney. I don't have money to be spending on an attorney for something that I don't think we in any way owe. And all I was wanting was a chance to be able to explain that and let a fair jurist hear it. That's all.
Well, that's a legitimate desire. But this ain't small claims court. You got sued in general civil court. The Michigan rules of civil procedure apply, and there's not special exceptions for lay people. I do grant much consideration to lay people, and I would grant more consideration if this was small claims. But you're in the weeds and you're in over your head. You got sued for $10,000. Your company did. You own the company, but it's a limited liability corporation. So you don't have the right to represent it. It's a separate entity. And so you may wish to have had a jurist hear this. And I've had a number of these cases over the years with small town, local, out of county newspapers, and they're interesting. And I'm sure the Waxahatchee Sun is an interesting thing, but don't put it on me.
I'm not putting it on you, Judge.
You didn't know the rules.
I'm not putting it on you. I'm not putting it on you. I'm sorry if I did that. That isn't my intent. My intent is to pursue whatever I need to do.
You made it sound like an insult, like you're not a fair jurist and you're not willing to hear my case. I would have been if you'd follow the rules.
Okay.
Anyway, the motion to set aside the default is denied.
Okay.
For the reasons stated on the record. Mr. Rognus, do you wish to, Mr. Tollefson wish to speak to Mr. Brooks?
I don't think so, Your Honor.
All right. Mr. Brooks, they'll be in contact about attempting to collect on this.
They won't collect it. See ya.
Yes, I'm sure that won't be easy.
No, it won't.
Seize your printing press or
Shame on
something.
you guys,
All right,
Dan.
you're good to go.
Shame on you, Dan.
All right, motion is denied. I've signed an order, Andrew.
Okay, but we already have a judgment, so I don't think we need anything additional.
No, you don't need anything else. Collecting on this judgment may be interesting, but the original judgment stands.
Okay, thank you.
Mr. Tollefson, best to you, sir.
Thank you, Judge.
Anyway, Mr. Hawker, do you understand that once we begin, any decision here is final? Could you unmute your microphone?
Yes, sir.
Mr. Banks, you understand?
Yes, I got a request of the court, Your Honor.
Yes, sir.
I'd like to request that the court dismiss the case against me based on the court lacking personal jurisdiction, as I do not reside in St. Joe County, and the court lacking subject matter jurisdiction, as the claim did not arise or any action or occurrence that happened in St. Joe County.
Well, Mr. Hawker lives in St. Joe County, and I have jurisdiction over you because you're here. He's claiming the statutory maximum, $7,000. He claimed he purchased a pair of jet skis from you, advertises working units. The engines are bad. He spent $8,200 on these jet skis. Now, normally buying something used without a warranty has got issues with it. But anyway, your motion to deny for lack of jurisdiction is denied. A, you're here. B, he lives here and he bought these here.
No, Your Honor, he bought them in Calhoun County.
All right, but he lives here. He lives in Sturgis at Lake Champlain. Mr. Hawker, why do you believe he owes you $7,000?
When I purchased the jet skis, he said that they were good units. They run, although he purchased them a year and a half prior to my purchasing them from him. He did not use them, but he still said that he would still stand behind them. So I brought them home. I put oil in them, and the one unit would not even start. So I took the units to the dealership in Kalamazoo, Ziegler Power Motorsports. They tested the unit that would not start and said that the compression was bad on all 4 cylinders. And they could not repair it due to not being able to get parts. It was such an old unit. The second unit I brought home. I could at least get it started, but I put it in the water for a test run. It blew out smoke, and then the engine seized up, and neither units are functioning. And the maximum damage allowable would be the $7,000. So that's what I am asking for.
All right. All right, let's see what we got here. How did you find these? Craigslist?
Yes, sir.
You understand how foolish this is? Gee whiz. 2028 Yamahas. They're almost 20 years old. There's no warranty from the company. Did he provide any warranty?
He said that they were good units and he would stand behind them.
I'm not sure that rises to a level of warranty. Mr. Banks, what's your position?
Yeah, I purchased them, like I said, a year and a half ago. I never used jet skis. I invested $1,500 to $1,800 that in equipment, new vests, new batteries, ropes, fire extinguishers. Due to a injury to my shoulders, I wasn't unable to use them. I purchased them as is. Like I said, never did anything, never had them in the water. And due to the fact that he had opportunity to grab them and test them before purchase, like other people had contacted me and asked they would have to do start them up and do a sea trial or whatever they needed to do to purchase them. He had that opportunity to do as well, but he chose not to, and he bought them as is. Like I said, I did give him all that stuff for free. I am well over 11,000 in new stuff that I added that I just gave to him with the jet skis. New tires, new fenders. I gave him the old tires as well. So
So this
tires.
included the trailer, a dual trailer and all of that?
Yes, plus the extras that I bought and purchased to ride them, but I never got to. So I'm 12 grand. I was 12. I gave him over about 12 grand worth of stuff in the deal.
You're both very foolish. You're selling something and saying it's operational and you never even put it in the water yourself. You're either fraudulent or willfully ignorant of whether these would run or not. They sat for some period of time without running through the winter. Don't know whether they're winterized properly, don't know whether they were sealed. Mr. Hawker, you're even more foolish. You see a Craigslist ad, you give a guy $8,200 for something and never bother to see whether it'll run or not. You also are now the owner of a trailer. He's not a dealer. He didn't provide a warranty. And so I'm not sure who's more foolish than the other. He sold them for $8,200. The trailer, how much is the trailer worth?
$4,000 alone.
That's hard to discern what a used trailer is. It looks like a nice trailer. So the way this works, he gets to keep the stuff and you owe him $7,000. So he sued you in small claims court. He's not saying, I want you to take the stuff back. I just want $7,000 for a functionally functional dual trailer and 2 wave runners that I never bothered to test. That seems unfair. He keeps the stuff, including the trailer, and you pay him $7,000. That's a pretty good deal for him, not such a good deal for you. The other side of the coin is he gets nothing. You sold him this stuff without a warranty. I'll stand behind him. I wouldn't exactly say it amounts to a warranty. You're not a dealer, and he never tested them. And he gets to keep the trailer, which I'm not sure how much it's worth. I owned a wave runner trailer at one time, a long time ago, and it was steel, not aluminum. So, Mr. Hawker, what's your last word here?
I will accept the court's decision.
All right, I don't like it really when you step back and look at it. I've said he's selling you this stuff that he doesn't even know whether it works or not. Expensive motorized equipment. He never bothered to start it, although neither did you. He made improvements to it, put new tires, fenders, other ancillary equipment like jackets and that sort of stuff, selling you saying, hey, I guess it works. In small claims court, the same standard of proof applies as to regular court. The burden of proof is on the plaintiff, and they have to prove the case beyond a preponderance. There was culpability on each side, on the seller's side for not knowing whether the thing even worked, on the buyer's side for not first confirming that 2 expensive pieces of water equipment that are almost 20 years old worked. I find a tie, in which case the tie goes to the defendant. Plaintiff has to prove the case beyond 50%. Mr. Hawker does have these devices, which are apparently have some value, and he also has the trailer, which may have some value to recoup against his $7,000. But allow him to keep both units and the trailer and $7,000 just is too unfair. The defendant was a private seller. He was not a dealer, and there was no express warranty. So I find for the defendant, the damages are 0. Mr. Hawker, perhaps you can sell some of this stuff and recoup some of your investment. But I find for the defendant. All right, thank you both.
Thank you, Your Honor.
But I have Miss Shelton and Miss Sublocke So Ms. Sublocke, would you join us, please? This is a claim for $3,055 plus court costs. Madison Shelton versus Kelly Sublocke. Will you both please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Yes.
Let me back up. We were here some time ago. This had to do with money that was allegedly borrowed by the defendant from the plaintiff. The amount of $3,055. Ms. Shelton was here on September 2nd, and Ms. Sublocke was not. So I entered a default judgment on behalf of the plaintiff. Ms. Sublocke then wrote me a letter, October 21st, and I wrote her back saying there's no appeal from small claims judgment. You didn't show up. And you didn't file the demand to set it aside within a timely manner. Then the clerk gave me something. What's a date stamp on this? November 10th. We learned that Kelly Sublocke never got served from the Postal Service. On November 10th, we got the certified mail returned to sender. Now, somebody signed for it on August 11th. Sue Chandler signed for this letter. So I accepted that as a certified proof of service. I don't know who Sue Chandler is. And then eventually the letter came back indicating that Kelly Sublocke had never actually gotten notice of the hearing, which is why she didn't show up. So we'll come back to that in a minute, ladies. So the letter that I wrote to her telling her that she couldn't move to set the default aside is in error, because if she was never served at all, then she can't be excused for not appearing for the hearing. Although we didn't know that until the Postal Service sent us something on November 10th, well after all this had taken place. So Miss Shelton, you were here back in September, and we made a finding in this case. I put you under oath, and you believe, now this was convoluted. It's a bunch of emails and screenshots and texts, and I frankly can't tell what is what. You did give me, however, a breakdown accounting of why you believe that she owed you this much money. And we sort of went from that. Miss Block, do you have that in front of you?
I'm sorry, what'd you say?
She gave me a breakdown that adds up to $3,055 of this money that she says that you owe her.
Okay.
So it goes back to December of 24. $900 December, 122 paid $200, $700 due. January 31st, $1,200 rent. Now it's $1,900 due. Paid $600, $1,300 due. Paid gas, food, no food stamps, $82.50. Now she says you owe $1,382 through February. Then February 25th, paid electric, food stamps, $295 divided in half is $147.50. She claims you now $1,529. March rent paid. Gas paid, cut in half, $81 due. Through March, she now claims you $1,610. Electric paid, $266, cut in half is $133. Now the total is $1,793. Then rent of $1,200 for March. Total now due is $2,943, water bill cut in half, 112. That's how she came up with $3,055. Ms. Shelton, is that correct?
Yeah.
All right. So we heard Ms. Shelton's version of why this money is owed. Ms. Sublocke, you didn't appear because you didn't have notice. And so the default that was entered was probably entered in error, although I indicated we didn't know it. So what do you want me to know? She breaks this down month by month on how much you owe. What's your response?
I have something written down so I didn't forget what to say. I sent you that letter, and a majority of what I wanted you to hear was in that letter. Let me see.
Yes, it's dated October 13th.
Yeah, that was just me explaining my side of the situation since I didn't get to appear and do that over Zoom with you guys when the court date was here. I didn't really
feel like she should have actually gone after Dominic Land, but
yes, sir.
she doesn't have to. I guess she can pick her
No,
defendant.
no, she doesn't necessarily have to. No, she could.
Okay.
I mean, she did just, I mean, she's going after me for it, but I don't feel like it's fair, nor was there lease agreement between us. I don't have the financial needs to pay that much money. I raised 5 kids by myself with no help from fathers. Not that it's anybody else's responsibility, but it would put me and my children in very much financial debt, which is why I kind of feel like her coming after me is a little bit more personal on her emotions because the agreement, when we moved in, the agreement was with Dominic's job, and her coming after me just kind of feels more personal. Just me and me only.
Well, as I said, she can pursue her defendant, but why not sue Dominic if he's another source of collecting on this?
Because I didn't make any agreements with Dominic. I only talked to Kaylee.
That's false.
Ms. Shelton, this goes under the category of no good deed goes unpunished. You took her in. They were in dire straits. You didn't have a lease. You didn't really exactly know what you were doing in the landlord-tenant business, but you tried to keep track each month of how much was due.
Yep.
Perhaps this could have been done better. Dominic was employed and responsible for paying rent. We paid rent for December, then he lost his job. They didn't pay January's rent, February's rent, March's rent. And so those figures are accurate. Now, this is a lot of rent for a basement. Probably not code compliant, but nonetheless, describe this house to me, Miss Shelton. What is it?
The 4-bedroom, 3-bathroom.
And which part of the house? They rented the whole house?
No. They did the basement. I offered the bedrooms upstairs, but the kids ruined like my closet door, a bunch of different things. So they stayed in the basement.
And what was down there?
It's like 3 rooms. It's like half finished. The walls need just the drywall on them. The floor has flooring.
How many bedrooms?
4.
In the basement?
Oh, no, in the basement, there's 3 rooms. They're not bedrooms, but there's 3 rooms.
Is there a bathroom?
It's upstairs. There's 3 bathrooms in the house.
And then what about a kitchen?
There's a kitchen.
So they had access to the bathrooms and the kitchen?
They had access to the whole house, yes.
So this really, the wheels fell off after the first month. And they did try to make some payments as they could. What happened to Dominic?
He lost his job in December, and I was freshly postpartum when we first moved in, so it wasn't as easy for me to find employment right away. When he lost his job in December, I was able to receive employment and paid Madison what I could. Dominic and I were going through issues in our relationship, and we ended up breaking it off officially in March.
Okay, so he's not in the picture anymore?
No, he has not been at all for almost a year. No, since March, sorry.
All right. Well, it's one thing is owing something, another is being able to collect on it. But I think this money is owed. Whether it's fair that they went only against you, I don't know, but we're talking about January's rent, February's rent, March's rent, utilities.
I do have a question for you though, because by no means did the agreement of utilities ever come up, not with me, not with Dominic. The agreement was made with Dominic because he was the one that was employed to pay half of the rent. And the utilities are just being tacked on. That was never, when me and Matt, right before I had moved out, Madison had asked me if I could help with utilities. And I had explained to her that I was giving her what I could because I was paying $250 in childcare on top of giving her what I could. Didn't have any kind of state assistance or child support to help feed my kids. My daughter was living off of $50 cans of formula every 3, 4, or 5 days, depending how much she chose to eat. Like I was really struggling financially, especially mentally. And I just wanted to be able to, it was my kids over anything else. And I'm sure anybody who's a parent can understand that. But the
well, do you agree that the rental amount was $1,200 a month?
Yeah, that's what they had agreed upon, was $1,200 a month.
Right. And was there a clause for you would pay half of the utilities?
No, there was not.
The deal with the utilities was when she moved in November, she had food stamps and she was getting about $1,700 in food stamps. And I said she didn't have to pay utilities if the food went into the house for everybody. In December, her food stamps got cut off. And at that point, I told her, okay, well, if you're not helping put the food in the house, I need help with the utilities now. And then she didn't have food stamps the rest of the time. There's a way that you
do that, Ms. Shelton. It's called a lease.
Yeah.
You're changing the rules in the middle of the game. I think everybody's on the same page that rent is $1,200 a month. So we've got 4 months, December, January, February, and March. So there's
I'm sorry,
40.
Your Honor. Can I say something really quickly?
Yes.
December, January, and you said December, January, February, and March. Those are the months that we did not pay at all.
Yes.
Okay.
Well, I'm gonna offset it by the amount you paid. The total amount of rent for those 4 months was $4,800. So let's figure out how much you paid. You paid $300 in December. You paid $200 in January. You paid $600 in January. March rent paid. Did she pay March's rent?
Yes.
No.
Or I thought she did. If I wrote it down that she did, she paid it.
All right, then she owes $3,600. So I'm going to subtract what she did pay, which was $1,100. Let's recap that. It appears that she paid $300 in December, $200 in January, She paid $600 in January. And I took March out of it. So 3,600 minus 1,100 is $2,500.
I'd also like to add that I didn't include the trash removal fees, also the damages to my house from her and her children. We had to load up 4 trucks of garbage and take it to the dump.
Yeah, I repeat what I said. No good deed goes unpunished. You don't have a leash. You're doing this on a handshake and a he said, she said.
Correct.
And so my advice is don't get in the landlord business like this again. And it's probably not code compliant. If this was in the city of Constantine or Three Rivers, you couldn't rent it like this. You couldn't charge somebody $1,200 to live in your basement. So I find $2,500 for the plaintiff, plus the court costs of $86.25. Total is $2,586.25. Miss Shelton, Miss Sublocke, I don't believe you presently have the ability to pay anything on this. You got 5 children and no child support help.
I make $13 an hour, Your Honor.
You're just barely keeping your head above water, but
I don't even
nonetheless,
think I'm above water.
this was a debt that was incurred. I took all the utilities and other expenses out of it. I gave you credit for everything that's been paid. So the motion to set aside, the default was set aside for lack of service. And we'll do a new judgment of $2,500 plus costs.
There's the Livingstons, and how do I say your last name? Is Acharya?
That is pronounced Acharya, sir.
Acharya.
Yes.
And then we also have Mr. Peterson, who's in court, and then Jennifer Hunt, who's on Zoom call. Those are the 2 cases we have where both parties are present, and we'll have hearings on those. We're going to start in just a minute. Before we do that, I'm going to talk to the clerk here. So she said.
Yeah.
So stand by there, Ms. Kowalski. Yeah. Great. So here's what I'm going to do there, Ms. Kowalski. We're going to start these hearings on these other cases. Someone from the civil office is going to come here. They're going to call back to Tennessee and see if they can verify service. If they can verify service, I'll bring you back on. We'll enter a default in your favor. But I can't do that till I make sure I'm sure that he's been served. So I'm just going to have you be patient for a while, and then I'll come back to you in a couple of minutes.
I understand. Thank you.
You're welcome. Okay. This number is some clerk's office in Tennessee. You're going to get a tree that says office, and then you go to the office, and then the case of the number is Kowalski. It's this one right here. And just see if they've been. She says she talked to him back there, and they said they've served, but apparently they don't have any electronic filing, so they put it in the mail. It's on its way out here. Okay. All right. Well. Okay. Yeah. All right. So Ms. Kowalski, I'll come. Yeah. Don't leave, but we'll take forward. In the meantime, see, the Livingstons can come on up and take a seat. And Mr. Acharya, I'm going to need you on the Zoom call.
Present, Your Honor.
So here's where we're at. You hear that again, we have two cases here set for hearing. And then we're going to start with the Livingstons and Mr. Acharya. Following that, we'll take up Mr. Peterson and Ms. Hunt. You've asked for orders for an anti-harassment order. I'm going to read a definition of harassment just to give an idea of where we're at. Is a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person and serves no legitimate or lawful purpose. Course of conduct must be such as would cause a reasonable person to suffer substantial emotional distress and much actually cause substantial emotional distress to the petitioner. Course of conduct is also defined as a pattern of conduct composed of a series of acts over a period of time, however short, evidencing continuity of purpose. Course of conduct includes any form of communication, contact, or conduct, and then, but does not include constitutionally protected free speech. And I just wanted to keep those things in mind as we go forward. Those are the things that are going to add up to or not harassment. So these sorts of cases are always emotional, and I understand that you're going to hear things you don't like. Both of you are going to hear things you don't like. All of you, I should say, since there's two of you and one, and maybe some other witnesses from Mr. Acharya. Are going to hear things you don't like. You're going to hear things you disagree with. I want all comments directed to me. Don't interrupt the other party. Don't interrupt me if I'm speaking, and I'll make sure that people won't interrupt you either. The way things go is I swear in the petitioners first. I'll hear from them, and then I hear from the respondent. And Mr. Acharya, if you have witnesses you want to testify, I'll hear from them as well. Following that, I'll make a determination whether or not an order should be entered or in some cases extended. Just a moment. Maybe just a minute to call the case up, and then we'll go forward. Well, it looks like in this case, a temporary order was entered. Who's going to speak first for the Livingstons? There's both Livingstons are here.
You want to go or you want me to go?
Okay, and I'm going to need you to speak loudly. Sometimes our microphones don't pick, and Mr. Acharya is appearing remotely, so you need to speak in a manner where we all can hear him. And ma'am, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Tell me how it is you need an order against Mr. Acharya. Are you folks, your folks are neighbors as far as I can tell?
We used to be friends. I met him through my husband when they were gaming together and
When they were doing what?
gaming. They video game together through Discord. We used to.
Go ahead. Tell me how is it that you need an order?
My husband had recently had some issues with him where he would point a unloaded weapon as a joke at my husband, and after a series of times of him doing that and then him threatening one of our neighbors who he's called as a witness, we decided to get a protection order because we've had issues with people doing that to us before, threatening us, and with a young child on the way and one in the home already, we just do not feel that that's a joking matter, or do we feel safe with him doing it?
Okay, so you're asking for an order basically because you're just included with your husband, and it seems to me like the big issue seems to be you two folks. Is that correct? Maybe
Yes,
you're the one. Okay, hang on just a minute. You're the. Do you have, first of all, do you have anything you wish to add at this time, ma'am?
No.
Okay, and then so Mr. Livingston, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Why do you think an order is appropriate in this case?
Well, to start off, Your Honor, we were friends for the start of it, and things were pretty cool until he decided to have homicidal tendencies, and literally.
Well, when did this, how long have you been friends?
No more than a year.
Okay. And when did this all go south, so to speak?
It would be probably in late October.
So like a month ago?
Yeah.
Okay. Everything was fine till then?
Yep, everything was fine.
Was there any sort of event that happened that made things go? I mean, I don't game, so I don't know anything about that. I have kids who do, but I don't. And I just,
It
and
was,
I'm not passing any sort of judgment. It's just not something that I think that's a generational thing.
But
I mean,
no,
was there a
it's,
gaming incident or what exactly?
the witnesses that he's calling.
I'm asking you. I don't. We'll deal with the witnesses at the time, but I'm asking you.
I'm getting
Okay.
there.
Go ahead.
So basically, the witnesses, they broke up, and he was getting involved with this girl, and her and her ex-boyfriend would argue a lot, and he would literally tell me that he wants to hurt this guy. Literally. Like that's all he would talk about is hurting this person, which is a witness that he's bringing, I guess. But not only that, but you know, this isn't the first time he's pulled a weapon on people. He's done it to the apartments that we live at.
How many times has he pulled it, use your terms, on you? Like I say, the people here
At
want
least
an
3
order, you
times.
do. I need to know what's happening
3
between him and
times,
you. 3
Your
times.
Honor.
Okay. Does he say anything when he does all this?
Nope, just having fun, joking around. Thinks it's funny, and I don't find it funny.
All right. Mr. Acharya, could you raise your right hand? Thank you. I may have some questions for you both in a minute. Do you swear and affirm the information you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
What's your response to what you've heard? You can put your hand down. And
Yes, of course, Your Honor. So Jason is, to say that, well, friend is a bit of an extension. A neighborhood bully would be more accurate. And to the point where, like, I try to be nice to people. I try to be associated with people, even people who I politically disagree with, even people who, deliver slurs to me and are harassing or aggressive, all of which Jason has done, because I'm LGBTQ. I am a socialist. Jason is not. I respect his political beliefs. I respect his First Amendment rights, but he has a colorful way of speaking, and I don't wish any sort of legal action against him for those cases. About the firearm, I had asked to see it a couple times. It was unloaded at the time. I did not point it. I did draw it from my holster because I open carry in accordance with the Second Amendment. And because I do not have a concealed pistol license, I must open carry. But I've displayed it to him a few times. I've never pointed it at him, and in all cases, when I open carry, I keep it unloaded. My 2 witnesses here can attest to that if you wish to speak to them. Otherwise, Jason has basically been, talking to me, and I've wanted to maintain an association with him.
you did or did not?
I did. I did for a while because I thought I could potentially politically influence him to be less reactionary, specifically about his interesting remarks about transgender and gay people. But at no point have I ever threatened him. At one point, I think the closest we ever got was one point we were play fighting. He has repeatedly attempted to ask me to threaten people on his behalf. At which point I felt relatively unsafe around him.
Who and why?
There was a block party. There was a block party around the similar date of the incident that Mr. Livingston pointed out, where he called me 9 times while knowing I was busy and on a separate call, asking that like he needed me, and he has also walked over to various people and said things like, "Hey, let's make him scared" and things like that. None of which sat really right with me. I don't think he's a bad man. I think he's misguided, but that's neither here nor there. Aside from that, he has bragged about using the police to get people who cross him. That is an exact quote, "get" and "cross," like is his exact quote. And he has mentioned that he has called the police on people for smoking 40 feet away from his house in an open space. He's repeatedly referred to ways in which he can use the police to irritate other individuals, and also tends to catastrophize local events. There was another incident in which Mr. Livingston asked to hold my pistol. This was actually when we first met. I was talking with an older gentleman. Mr. Livingston approached and seemed to know them, and I was okay. And he invited me to sit down in his truck with him. So I sat down in his truck with him. He asked to hold my pistol, and I allowed him to. And then he started talking about how he was a felon, had gone to juvenile detention for trying to murder his own father. At which point I asked for my pistol back because I'm aware that felons should not be, I believe, legally they should not have pistols. Another time, he encouraged and I only recently found this out, encouraged a member of the police force who was leaving their job, who had just joined, a rookie member of the police force, to call the police on me because I was jogging with military-style clothes. Jason then provided a sympathetic ear towards me and never even mentioned that he was the person who had attempted to report that. It was because I was wearing military-style clothes and I correctly identified the dog the rookie was walking as a former canine, because as a former security guard, I've worked with law enforcement, and so I was just familiar with canine units. At any rate, Mr. Livingston has been an absolute pain to deal with for about a year to a year and a half now, and I didn't want to make him feel bad, frankly, which is why I continued to engage with him. And when gaming was mentioned, I have played a grand total of 1 game of Helldivers 2 with him for about half an hour, and that is the extent of gaming that I've done with him. I have my 2 witnesses here, if you would like to speak with them.
Sure.
It's Robin, John, it's one of you. Yes, he has also threatened one of the witnesses here, who I did not threaten. Neither did I point a weapon at. This witness is here.
Okay. Well, I'm going to need to hear from the witness.
Yes, he's going to take a seat.
Yeah. Hello.
Hi there. What's your name?
My name is John Reed.
Can you raise your right hand, please?
Yes.
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. What do you know about this? And I'm asking about the interaction between the Livingstons and Mr. Acharya. Do you live in this neighborhood?
Yeah. Yeah, I'm also a neighbor of all of these parties involved. Well, as it's been mentioned, I think I was friends with Jason first, like before anything else happened, more or less. We kind of had a falling out for reasons I don't really understand, which is around the same time that these other things started happening. I I don't have all the details about what. I mean, I have obviously like secondhand accounts from people, but my understanding is that uh, Shiv hasn't done. Oh, Nathan. Oh,
Yeah.
sorry, legal name Nathaniel. Hasn't done anything that merits concern. He's never been threatening to like me or anything, and I guess there was concern that he is a threat to me or something. I don't really understand that, but I don't think he's threatening at all. He's extremely thorough about gun safety. I could never imagine him flagging anyone with a pistol. That's I don't understand that. I don't think that would happen. But I mean, more or less, things are civil. I don't think there are any threats here. I have not been privy to harassment coming from Nathaniel. So, I mean, I guess that's all I have to say about it.
All right. Let me hear from the other witness, and I'll give you guys a chance to respond in a minute. What's your name, ma'am?
Kelly Vance?
Can you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. What do you know about this situation?
Well, much like Mr. Reed had said, a lot of the information that I get is secondhand because this is a situation that is primarily occurred between Mr. Livingston and Mr. Acharya. But I'm more or less here to be a character witness. I agree with what Mr. Reed had said about Mr. Acharya's firearm hygiene. He certainly has never displayed anything but, very proper and appropriate handling of his firearm. He always keeps it unloaded with, ammunition at the ready if he does need it. He has certainly never done anything in my presence that warrants concern from me. All around, it's civil. We're very, very much friends. Talk every day. Mr. Reed and
Do you live in the neighborhood also there, or do you all live in the same complex?
Correct. So Mr. Reed and I currently live together. We were dating, but we have since separated, but we are still living in the same apartment. But routinely, we all do get together and hang out, watch movies, that kind of thing.
All right. I can have you step off, and then Mr. Acharya can come back in. And then I'll come back to you, Mr. Livingston. What's your response to what you've heard from all three of those folks?
Well, from what Nathaniel is saying, I don't know what he's talking about, honestly. And the witnesses weren't really there, so I don't know how credible that is.
One thing that you had said there, Mr. Livingston, and it's both in your petition, that this was done, and I'm not suggesting it's funny, but as a joke, that was meant to be a joke.
Yep, you just thought it was a joke, and I just don't see it as a joke.
No, I don't either.
He comes to my door quite often, sometimes. Says he's doing a routine check or something. I don't know what that is, but if this protection order wasn't in place, I'd fear for my life.
Mr. Acharya, what's the story on that? You go to his door?
Oh, I've gone to his house about 3 times, mostly when he has invited me over. Usually after he's called me multiple times to ask me to spend time with him. And let's see, I believe I can recall 3 times. So twice he asked me to spend time with him, and one time I was delivering something to him from somebody else who had asked me to bring it to his house. That was it. I have said periodically that he should be checked up on, mostly because I mean
Well,
I
it's not your
was.
job to check up on him.
Oh no, I'm aware, sir. I'm aware, Your Honor. But I have said he should be. I have never checked up on him.
Here's where I'm at on this, to be frank with all of you. And I heard from everybody, Mr. Sharia, and you too. And I read the definition of harassment at the beginning, and I'm going to do it again. Have it up here. Is of course, harassment is the knowing and willful course of conduct directed at which seriously alarms or annoys and serves no legitimate or lawful purpose. And so it has to be something for that purpose. He's trying to harass you, and by your own testimony, you said, well, he's trying to be funny. Well, I don't think it's funny. You don't think it's funny. But a bad joke or a bad sense of humor doesn't necessarily rise to the level of harassment. It can become that. And so at this stage of the proceeding, I'm not going to enter a full order. The order will expire today. Mr. Acharya, these people want no contact with you. Do you understand that?
Yes, of course. I want no contact.
Any further contact would be considered harassing at all.
Yes.
And so,
Your Honor, might I ask?
You should probably stop, but go ahead. You can go ahead and ask.
Oh, I was just going to ask a couple follow-up questions. I also want no contact with them. They filed the no contact order approximately 3 hours after I had asked the complex if they could file a no contact order against the Livingstons on my behalf. And then they
can't.
Yes, they presumably informed the Livingstons, and then they filed the order, which at that point, which is why I wanted to mention that it feels retaliatory, though I have no issue complying with the no contact order. I want no contact with them at all myself.
Go ahead, ma'am.
We had no idea he wanted no contact with us, as he made it appear that we were all friends.
Right.
And as someone who's just, a person outside of what's going on, I would just like to remain friendly, because we're all neighbors. We shouldn't be having any disagreements.
I agree with that. And now that you've aired some, for lack of a better term, neighborhood laundry, I don't know if I want to call it dirty laundry or not, hopefully you have a better understanding of where you're coming from. So, Mr. Acharya, it's not funny to do that. Don't do that. Don't do that. Don't make any, so again, it seems like you both want the same thing, in the sense that you don't want to be around each other. So don't be, don't be involved in ganging, and don't contact him to want to come over and hang out. He should do the same. And, but again, this can be refiled from either party, basically at any time. So if there's additional, so how they feel about having contact with you, so don't go by and check on them. You don't need to do that. But, if there's any additional contact, you would probably deem it harassing anything further. All right?
I did have one last thing I wanted
You may.
to say. I did want to say that on behalf of myself and my husband, that we do hope things get better, and down the road, maybe we can be good neighbors, because we don't like conflict, but at this point in time, we would just remain in no contact.
You hear all that there, Mr. Acharya?
Yes, I would agree with Miss Livingston there. I don't want there to be issues. I felt unsafe. They felt unsafe. Clearly, there was miscommunication on both parties.
Just stay away from each other.
Of course.
Good luck.
Oh, may I, Your Honor?
Yes.
My firearm was confiscated by the sheriff's department. Might I have it back at some point? And how would I do that?
Yeah, you can ask to have that, but you need to, yeah, I've checked the box there that they can be released, and you can get it back.
Thank you very much, Ron.
And Ms. Hunt, can you come on the Zoom call? There you are. Give me just a minute. I'm going to call up the, your case. Okay, so Ms. Hunt, I'm going to hear from Mr. Peterson first, and then following that, I'll swear you in, I'll hear from you, and then I'll decide whether or not you need an order. So Mr. Peterson, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. How is it you need an order against Ms. Hunt?
Well, she's constantly threatening to burn my trailer down or tow it away. And she has literally burnt my trailer, my fifth wheel down like 3 years ago. Literally when I was inside, she lit it on fire. Okay, and these are just things she's done in the past couple of months.
Do you guys live near each other?
Well, she got served. She got served on Tuesday, and that night, for some reason, she packed up all of her stuff in a truck and brought it.
Do you live next to each other?
No.
Okay. Did you?
No.
How does she know you? What's this all about?
I've known her. She's my ex-girlfriend. I've known her for the last 10 years.
I see. Well, continue on.
Okay, the past few months, she's busted out my two windows in my trailer. She has graffitied. I have a fridge outside. She graffitied on that, on the door of it, and on the front door of my trailer. She's broken into my trailer. I don't know how many different times. I'd have to fix the locks. You know, she's breaking it. And it's been a few months, about 6 months ago though. I was working out of town, and she would break into my trailer and just move in and stay there while I was working out of town. And she's stolen my cat before. She's sabotaged four vehicles by putting soda pop in the tanks. Like one time it cost me $900 to get this vehicle going again. I mean, she's popped tires in one of my vehicles before in the past. Let's see. She literally like burnt a bunch of cedar that I've saved, that I split for this old lady because she's too old to split it, so I keep her supplied on.
How long has this been going on?
A lot of these things that just happened in the past couple months, but some of them are old, But like I said, she's been constantly threatening me lately to burn my place down, and she's done it once before in the past, and she's trying to threatening to tow my trailer away.
Let me hear from her. Ms. Hunt, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. And then what's your response to his request for an order? Basically.
Okay, my response is that we both are currently living on the same property. I'm moved on the property due to the previous place I was living at. There was a person there that was beating me with a baseball bat repeatedly, and I didn't feel safe anymore. And
I'm going to need you to slow down a little bit, ma'am. I'm having trouble understanding you. But maybe a technology, but go ahead. You say you live on the same property?
Yes.
Okay.
On the same
so
property.
Hang on just a minute. Do you pay rent where you are?
Yes,
okay. And then who do you pay rent to?
To the person that owns the property. Her name's Jamie Frost.
Okay, so hang on just a minute. Just stop.
Oh, sure.
So, ma'am, do you pay rent when you live there?
Yes.
Okay. When did you move there?
I've been here about a week so far. But I also
you just moved on a week ago?
Also. Yeah, she's a witness also for my case right now. Jamie Frost, the owner of the property. And I also moved here because she has stage 4 breast cancer, and I'm her caregiver. And I was for about the past 2 years. I've been here like 75% of my time, traveling back and forth between Centralia and Rainier. And due to the incident with the baseball bat and getting beat by it, she felt it'd be safer for me to be here, and it'd be better for me to be here 24, living here due to the fact that I take care of her.
Okay. What about all these things that Mr. Peterson, I know your name. Peterson is telling me about broken windows, graffiti, burning places. What's your response to that?
Well, my response is that we've had a toxic relationship for 10 years now, and I understand that he lives on the same property, but I'm just requesting that if you have to grant this protection order, that you just take it down to 50 feet to where, because I've always given him my word that I wouldn't go near his camper trailer that he lives in. And the property owner, Jamie Frost, has also told him that I gave her my word that I wouldn't go anywhere near
Okay,
him.
so hang on just a second. Is she there? Is it Jamie Frost, did you say?
Yeah,
And
she's
that's what you
here.
pay rent?
Yeah, she's breaking the order right now.
What's that?
She's breaking the order right now for being there.
Okay.
She's been served by the
Okay,
police.
just, you need to be quiet, okay?
Yes, sir. Yes, Your Honor.
I can't give her that. I see her.
Hello.
Hi there.
Hi.
So, what's your name?
My name is Jamie.
Jamie what?
Jamie Frost.
Okay. Could you raise your right hand, please?
Yep.
Do you swear and affirm the truth, the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
So I just have a couple of questions for you, if you don't mind.
Okay. Okay.
So both of these people live on your property?
They do.
Okay, and then I understand, is Ms. Hunt more of an off and on thing?
Well, she's moving here permanently now.
Is she living with you at your, just stop, please. So you live in a house?
Yes, I do.
And then does Mr. Peterson rent space from you, or is it a trailer?
Yes, he does. Yes, he does.
Okay, so you know all these folks?
Yeah.
Okay, how close do you live to Mr. Peterson's trailer?
I'm not sure. Like, he lives on the backside of my property.
Okay, how big's your property?
It's like 2.5 acres.
So, okay. Thank you, ma'am. If I have some additional questions, you can put Ms. Hunt back on there.
Okay, thank you.
And how close do they live to you?
About 30 feet. No, probably 50.
50?
50 feet. Yeah.
I mean, 50 is not very much.
I know.
2 acres is.
I know.
Yeah. All right.
I know. And can I speak, Your Honor? Or?
So I will tell you this, ma'am. Yeah, Ms. Hunt and Mr. Peterson, based on what I've heard, I am inclined to enter an order, but the distance, but I can't do an order that makes her, now if she lives there, apparently she does, just hear me out for a second. I can't do an order that prevents her from coming to her own home, but I can put a distance restriction. She's not to come within X number of feet of your place. So if she comes and you said she's done these things, she agrees it's a toxic relationship, and I can pick up on that just based on what I've heard thus far. And so, ma'am, you need to pay attention to that distance restriction, because that may affect your ability to continue to live there. Do you understand that?
Yes, sir.
Okay.
You wanted to say something, Mr.
Yeah,
Peterson?
she didn't move in there until the day Tuesday night with the temporary no conduct order. Okay, and I went down and brought the papers to court on Wednesday.
Right.
Okay. And she already, so she hasn't lived there, and she just, pulled this at the day she got served. She moved.
How long have you known Ms. Frost? Sounds like you all know each other.
Well, yeah, I know Frost for years.
Okay.
But-
And
and
she
then-
has too, apparently.
Yeah, and then, so I did call the cops on Saturday,
Right.
because Jenny Brooks, no kind of order. The cops came, but the it hasn't gone through to the courts yet, saying that she's been served,
All right.
because I didn't get here till Wednesday, and the courts was closed Thursday and Friday. So I'm sure you have it on your desk now, though, or it should be somewhere, because I
Yeah, no, let's have, we got proof of service.
Okay, so and the cops told me that they're gonna, if they find out that they got proof of service, that they're gonna charge anyone for lying to the cops, because Jenny told, she lied to
Okay,
the
so
cops.
look, I'm not gonna get into that. I don't, what the police knew and when they knew it, and whether she was in violation of the
So-
temporary or not. I'm not gonna, that's between the sheriff's office, you, and the prosecuting attorney's office.
Okay,
That's not something I'm finding here. The only thing I'm finding here is whether or not it's appropriate that an order should be entered. An order will be entered, but I'm gonna do a distance restriction. Ma'am, you said that you can keep within, you suggested 50 feet, and you're,
Yes, sir.
So basically, I'm going to go along with that suggestion. You're not, it'll be in place for a year and you're not to, and then Ms. Frost, I hope you're hearing this also.
Here, I'm here. I'm right here. I can hear it.
Ms. And I'm understanding, is Ms. Hunt going to act as a caregiver for you? Is that what I'm hearing?
Yes. And she promised me that she's not gonna go near Adam's trailer or near it, so 50
Okay.
feet, that sounds great.
Then I'd rely on you to hold her to that promise. And then that's
I'm
going to be
gonna
it.
try.
She's
I'll
not
do my
to,
best. I'll do my best.
give me just a minute. And you both used to be a dating relationship, is that correct?
Yes, that's right.
And then how long ago did that break up?
Oh, that's a long
Never
time
been,
ago.
never been in a relationship.
Well, it seemed time for both of you, and by both to move on.
I agree, sir.
So ma'am, you're not to cause him any harm. Don't contact him. Don't engage in stalking behavior. Don't come within 50 feet of him, his residence or place of employment. And then, does she get an emailed copy of this or not? Do we have an email address for you, ma'am?
I believe so.
Okay, a copy of this will get emailed to you. And, Mr. Peterson will give you a copy of this right now.
Well, how do I get hold of the officers that came to the house the other day? Told me that they were charging her. She was lying.
You need to, whatever agent was at the sheriff's office or,
Peterson County.
yeah, then you need to talk with them.
Okay.
But, you know, I guess, and you might want to ask yourself, is that making things better or making things worse by kicking that particular hornet's nest? And only, I can't decide that, only you can.
So straight, you know, she straight lied to the cops.
Okay, I'm just, okay, look, I'm not, that was just something for you to think about, all right? And you'll get a copy of email. We'll print you a copy. Once you get that, you're free to go.
All right.
Good luck to everyone.
Thank you, sir.
So do I wait here for
Yeah,
the
wait,
papers?
we'll give you a copy of that.
I'm done, right? All
You may go, Ms. Hunt.
right, thank you, sir. Bye.